take 2 or 3 slides out of this. One is each one of you go back to your tribal nation, I would recommend, and do a presentation like this based on your research of what does your treaty say in your land area. And it's not just what the treaty says, there's also the area that is unceded. Because one of the colonized behaviors is that the treaty folks will put down the people who didn't have ancestors who signed the treaty. The people who didn't sign the treaty are just as elevated because they didn't cede any territory at all, which is the women. The women never signed the treaty. And so there are parts of the Black Hills for certain bands, like the Yanktons, never ceded any of our hunting rights and our fishing rights in the Black Hills. We didn't sign the 1868 treaty. The 1868 treaty is a grand treaty, but it also, there's certain parts where hunting rights were ceded in the Black Hills Treaty. So you have to examine each one, and it's like that matrix, that example that Kimberly talked about it. You really have to evaluate it and say, if I'm going to talk about treaty rights, how do I need to behave? Because the largest way to, or the most powerful way to behave in regard to a treaty is to view it in a decolonized way. So when I go through this, you can get an idea of how do I do that. And I have this wonderful hero currently. Each year I have a different hero. My hero this year, and actually he's been over the years, is a guy named Newcomb. And if you haven't read this book, I had a chance to be a keynote speaker, and Stephen talked right after I did, and our presentations kind of complemented each other. But he's written this book called Pagans in the Promised Land. And what he's saying is probably what all of you have thought at one time or the other. He says that the federal domestic law, meaning any lawsuit in federal court, evolved from fiction and imagination of non-native people. It's pure dysfunction in federal law. So you have to be really careful about what you take to court, because their ideas and their judgments become policy and laws that sometimes trample, majority of the times will trample over our human rights. So having said that, how do you stand by your treaty? The way you stand by your treaty is the way you talk about it and the way you behave. So I will review the 1851 treaty and the 1868 treaty briefly, and you can see the danger areas. You can also see the areas of strength. And in both treaties, 1851 and 1868, the important thing is it gives us a political and a legal standing as a nation in international law. And if that's all it does, that's powerful. Because I can stand here as a member of a nation in international law. So there's this one here where I say my tribe, my nation, acted individually in a legal, political way of strength. The other way, which is kind of scary, is, and hopefully young people can become really fluent in this international standing, because we have more power than states. So we have to figure out how we exert that. Over here is federal domestic law, and this is where elected leaders come in. Your chairman, your tribal councils. Over here is the general councils, the ones that didn't have IRA, and they stand by the treaty. The third one, if I could have that chair over there, is the unceded territory. This is where no one signed anything, and you still go out and you gather, and you still, and that's the behavior, is I'm gonna go to the Black Hills every whatever season, and no matter what, I'm gonna gather. I'm gonna go down and I'm gonna fish, I'm gonna do all this stuff, but I'm gonna do it in a way where I don't end up in court. And sometimes you accidentally end up in court like I did. But I'm a good talker. And so that's this grassroots, this is where the grassroots come in. But all of them have to work together, and that's the behavior that we have to relearn. Because the one that is out front when we have these meetings, like I saw that in Reject and Protect in Washington, D.C., right away they grab the tribal chairman. Right away they grab the tribal council. What about the ones back here? The women, the grassroots. So what we're doing is we're doing active colonization. Can you see that? Very active colonizing. We're doing exactly what they told us to do. So what we have to do is, when you have that meeting, the way the room looks, you have the tribal chairman, you have the treaty council, you have the grassroots, they all walk in together. In the sacred circle of life, there is no one who's greater or less than. And you have to behave that way. But the federal government likes federal domestic law, which is the tribal chairman, the tribal council. There's laws that have absolute power over them. And so we've been colonized to think, oh, where's the tribal chairman? You can't talk, you gotta have your tribal chairman there. So it's not that you have to fight with your tribal chairman, you educate them, you decolonize them. And so that's what our treaty council has been doing, is to say, hey, you can't go to that meeting without me. For example, when J.R. LaPlante would come down and meet with the Yankton from State Tribal Relations, and he's gone now, he's been in there 4 years, and he went to the U.S. Attorney's Office. Whenever I'd hear that, the other thing is, tribal or treaty committees, treaty councils get starved. This group doesn't share information with them. So what I learned when I got on the Treaty Council, which was 6 years ago, I'm the chair of our Treaty Council, I figured out I had to stalk these guys. You know, I had to actually say, what meeting is this? Shouldn't I be there? Shouldn't we be there? And when I figured out tribal state relations was coming into our territory, and I saw J.R. LaPlante's car drive by, I started stalking him. And I said, hey, whenever you come into my land, my territory, you be sure and call me. And he said, what do you do? I said, I'm on the Treaty Council. He said, oh, I called the tribal chairman. I said, you didn't hear me. What did I say? Call me. Oh, okay, well, the tribal chairman will let you know. See, that colonization is so deep. And I said, no, the minute you enter my boundary, I said, you better let me know. And of course, I have grandma status, so that helps. And so I kept after JR, and pretty soon, it's like he didn't even come near Lake Andy's Wagoner or Marty unless he called me. Because the Treaty Council has to be there, the grassroots have to be there. So then last year when he was retiring, he gave me an award for chewing him out. That's decolonizing behavior, not chewing out people, but asserting and saying, there's this picture, this schemata. Just like the Washichu people, when they did their federal domestic law, it really was their imagination. And so if we imagine it to be this way, this is the way it's going to be. So we have to imagine it that there's equity. You know, there's roles that we have to play. We don't fight each other. Especially we don't fight each other in public. There's certain protocols that have to be followed. So with that, the other thing, if you can be sure and read this book that he says, and I want to say this first because as you understand this, as I go over the treaties, you're going to see all the loopholes. He says something which I think is really key, if I can find it, and I probably can't. Can you read this for me, Tushka? This paragraph.
Me.
Blah, blah, blah. Here.
All right. Federal Indian law is premised on the notion that the U.S. government has a legitimate plenary authority to place certain non-Indian conceptual constraints, otherwise known as laws, rules, and regulations, on original, free, and independent American Indian nations. In terms of cognitive theory, federal Indian law presumes that the United States has a legitimate authority to, quote-unquote, lay down conceptual boundaries for American Indian nations, and that once those boundaries are established, Indian nations are then obligated or bound to obediently stay within and move along the paths formed by these conceptual boundaries. As we proceed, we shall see that from an indigenous baseline perspective of an original, free, and independent existence, the presumption that the United States has a legitimate right to lay down numerous laws and policies for Indian nations is rooted in the idea expressed by Chief Justice John Marshall in the Johnson ruling that the first, quote-unquote, Christian people to discover lands inhabited by quote-unquote heathens has ultimate dominion over and absolute title to those lands.
What a bunch of crap. Really? It's their imagination. Pure dysfunction. And it's rooted in, I'm not against good Christians, but in all paths lead to the Creator, but it was based on papal bulls that were created in the 1500s. And so what he's saying is really, really important. I was so just taken by the knowledge that he's put together the last 20 years in fighting this fight. And his worst opponents are federal Indian lawyers, are native lawyers, because they went to law school and they learned how to fight in this federal domestic law. But what he's saying is that back in, and Kimberly, are you still on the phone? You can help me out with this one. But there's the what do they call it? The trilogy, the Cherokee Nation trilogy.
The Marshall
Trilogy. Yeah. So what happened there in around the 1820s is that the federal law, based on this dysfunction that he just read about, the first one was, what was the first one? On the Johnson versus McIntosh. And that one voiced that what the doctrine of discovery said is that they had the right to come in and with conquered people, and they would take the land. Because they had conquered us, they had dominion. In the Johnson versus McIntosh case, Steve talks about in here that there's a word called ascendancy. And the same words are used in the doctrine of discovery, which means that they use this directly in the Johnson versus McIntosh, which is still used in federal Indian law. So if we abide by that, we're complementing the doctrine of discovery. So it really, and this is probably one of the best, and I'm sure Kimberly has other ideas, but there's several books, but this one by Uncle Dixie Vine Deloria, American Indians, American Justice, it gives a layperson's view of the court cases that you need to know that set the framework for how people judge us in federal Indian law. The second one was Cherokee versus Georgia. In that one, what happened was they said that Native people were domestic dependent nations, that we really couldn't live by ourselves, that we were dependent on the United States. The Yanktons have a treaty that actually says that, which is doesn't make me happy, but I wasn't around in 1850. But it says that but we can use it to a certain advantage, because it says that if depredation occurs, the United States government should protect us. But what if the depredation is the United States government? So that's one we have to figure out. It's like the beast, eating the entity that they're supposed to take care of. It's like Ia coming into our lands. So we have to figure out how to use that treaty. So, and then what's the third one? Worcester
means Georgia.
Georgia. And that one says there was kind of a good side, but not very good, but it says that the state of Georgia didn't have power over the Cherokee Nation, and there were certain things that they could assert. So that one we can still use. But we have to be very careful, because all of those are going to determine how we stand in treaty and federal law. So you absolutely don't want to go into court unless there's an alternate way that you can do it using your treaty. And most of that is behavior and speech. So let me give you an example. I took some elders down to White Swan to pray after we went through this big old thing with NAGPRA. And there are some federal laws that you can use, the Federal or National Historic Preservation Act laws that Kimberly talked about in that first condition, that they have to abide by all of those laws. They haven't. So that gives us a door to move in there and use their laws against them, especially in cultural resources. So I go down to White Swan. It's after the big battle that we won in court. Cost us $200,000 to enforce consultation. And in that court case, Judge Pearsall said, the Corps of Engineers said that they consulted us. And we said, Not even. You didn't even consult us. And they said, we left messages at the tribe. We talked to this tribal person. We talked to that one. What Judge Pearsall ruled in January of 2000, he said, silence does not constitute consultation. Big one. You can refer to that. Write that one down, because in your tribe, you can bring that back. Just because they left a message does not mean that they consulted. So we can use that in this current battle that we're in. On the FEIS, they said that this is carried away crazy. They said that they consulted Yankton 159 times. That's literally impossible to consult with somebody 159 times. Whoever heard? Talk about dysfunction, lying. And so there's lots of doors that we have to investigate, and we've already made those statements in the FEIS. So I took several elders down there to pray, because in January, the water goes down, Fort Randall, they let the water down, the old burial areas come up. So we go down there and we pray and we make offerings, just like, the keeping the spirit that has somewhat modified to this day, where we feed our spirits. So we get down there, and it's too far for them to walk off the bank. So I take my little pony Tahoe and I drive out where the site is. Pretty soon I get a phone call, and these two guys at the Corps of Engineers, they're always stalking me. My phone rings, and it's Cody Wilson, and he says, Faith, what are you doing? What are you doing down at White Swan? I said, well, obviously you know that I'm down here, right? And he said, you know that you're trespassing, you're not supposed to go out there with the vehicle. I said, Cody, there's tracks out here. You drive out here all the time. Yeah, but I work for the government. And I said, I work for a government too. It's the Yankton. I'm a member. And he said, well, call me when you're done. He said, we got to talk. So I thought, oh, here we go. And I hung up, and we went ahead and did our prayers. 2 weeks later, I get a ticket in the mail. And there's a summons for me to go to federal court. And it says that I trespassed. So I went to the tribe, and they're the ones in this chair here. In this chair, in this arena, they're kind of way back here. They didn't support me. I said, this is huge. This is freedom of religion. They didn't know what to do. And they're not bad people, they just don't know how to behave. They don't know what to do. So they just kind of stayed back there, and I thought, and then I remember I talked to my son, and I said, he said, what are you going to do, Ina? And I said, well, I'm going to go ahead and appear. And he said, well, you've been working hard, maybe you need a rest, maybe it'll be all right if you're in jail for a while. And I said, not even. And so he went up there with me to court, and the judge asked me, he said, how do you plead? And I said, this doesn't even have anything to do with pleading. I said, I'm just praying. I was praying. Has no relevance to guilt or not guilt. I don't even know what that means. And so he asked me what I was doing, and I explained it to him. And then he looked at his prosecutor, and he said, back into that imagination over there, he said, how many days do you think this court would take? 2, 3, 4? And I thought, oh, here we go. And I just kept on praying, and the prosecutor said, Your Honor, I think I probably should visit with her first, and let's see where we can go with this. And he said, okay. He said, get back to me and see what we're going to do. So we went into a side room, and he asked me what happened. And so I told him, and he said, the court's going to be really PO'd at me, but he said, there's no grounds here. He said, you're familiar with all of those laws, and this is a freedom of religion issue. And he said, you have every right to do that. And he said, they're going to be pissed off, they're going to call your tribal government, but he said, I'm going to go ahead and dismiss it. And that was huge. And so I went and I told the tribal government. They had no clue what it meant. I mean, that is big. That's all of those federal historic preservation laws plus the unceded territory part. So, but maybe if someone went down there and didn't know, they could have ended up at this court. They might have pled guilty. So it's really important for you to know these things in the background before you haul around and do all of this stuff, because you need to know what you're risking. And it's really scary if you're uninformed. And especially even more if you're colonized to the extent that you don't see the value of these two other chairs. Really important. We had another case where someone hollered about standing on the treaty, and it really hurt us. We had a hog farm, a cattle that came onto our reservation, and my nephew Owie was involved. He took a very brave stance in that action. What happened is the tribe obviously opposed it. One individual hollered the treaty issue. She acted as a parent of a Head Start. She took it to federal court. The tribe, I told them, I said, tell the federal court she doesn't represent the tribe. And of course the non-native lawyers, they were happy that she was in there because she was literally standing alone. And they made the judgment against her reflective of the Yankton Sioux Tribe. And we lost that one. Really, really sad that that happened. There should have been some injunction against her, and that would have caused a family war. But that, that's scary because they didn't totally understand it. So consequently, we ended up having to, stand before the bulldozers again and do all of our antiques, but it was already done in this federal domestic law. So that's the thing. In that case, I think we learned some lessons, and that's what Dallas and Sabrina have talked about, is we have to review what we've done in the past when we stand on the treaty, and we have to say, oh, no, I'm not going to do that again. Or maybe I should do this. Maybe I need to be consulting someone within the ranks to figure out what's the safest stand to take. So at the hog farm issue, there's something called that I would urge you to use in your treaty work. You all know what UNDRIP is, right? United Nations Declaration on the Rights of Indigenous People. There's a very important article in here, and some people will say, oh, that has no power. You can't legally enforce that in a court. And it goes back to the same mandate of behaving as a sovereign. When you talk about your treaty, behave like a sovereign. This is my right. When my ancestors signed that treaty, they used the chalupa. So this is not just between you that have this carried away imagination. It was done with Creator, with prayers. So when those commitments, that Wochuza and that document, that Woapi Sudaya was signed, it was greater than them. It was between Creator and our people. And in here, when it says Article 10, free, prior, and informed consent. Article 10, that nothing can be done like what's happening up at Cheyenne River, what's happening here with your transmission line. That's what you need to investigate, probably, the Lower Burl people, is study this document and see how some of this has been violated. And be careful about risking it, but when you can sneak it into court, sneak it in. When we had our jurisdiction case down at Yankton, the federal court didn't want us to, they said, rather than going to the Supreme Court to do the Yankton case again, because it's costing hundreds of thousands of dollars for each side, let's try to do a mediation in Sioux Falls. So our tribe said, okay. So you know what I did in our position? I wrote 4 articles into our position out of here. And the judge who was presiding didn't even know about this document, and I didn't explain it to him. I just wrote it in there. So free, prior, and informed consent, articles, I think 24 and 25, regard to violation of natural resources, territories, gathering. And so sneak them in when you can use them. You don't have to wave it around and tell them. There's some things you shouldn't tell the enemy. That's one thing that we have to decolonize, because when we're mad at our relative, we see the government as mom and dad, and we're going to tell on our relative. So you want to be sure and not wave this around, but use it as much as you can. It's a document that has been adopted by numerous countries. The United States adopted it finally, but it says that it's not enforceable in a court. So sneak it in. Just sneak it in however subtly that you can do it. But try to get it, you can get this offline. This one was done by the College of Law at Arizona State, but be really familiar with this document. So when we do this thing in January, I haven't had a chance to visit with Thomasina Realbird about the UNDRIP organization or document, but I know that we've used it before in the KXL fight. It's already in the documents. So we'll continue to do that. So I wanted to do that prelude before I talk specifically about treaties. Any questions, comments?
I thought you were gonna say, I just want to say that before I start talking.
Yeah. I haven't started yet. Oh, no.
Do you want me just to skip ahead to pieces?
Yeah, I just need to go,
All right.
keep going
Down?
down. What a treaty is. What a treaty is.
Yeah.
Okay. All right. Oh, it's not showing. There it is. Okay, what is a treaty? You probably can't see this, but I could email this to people. Under principles of international law, it refers to any agreement, compact, or alliance, convention, act, or contract between two or more independent nations with a view to our public welfare. So in our treaties, various treaties are summed up to say, when our grandfathers signed this, we were giving this land in exchange for health, education, and welfare. So you bet the tribal chairman better sit with the treaty people, because the majority of our tribes are treaty tribes. You wouldn't have Indian Health Service. You wouldn't have the schools. You wouldn't have the aid to distress, some of the things that we have going, if you were not a treaty tribe. So the treaty has relevance, so educating yourself not to fight or to put them down, to just be there, assert yourself, and become fluent in this. Under the U.S. Constitution, technical application of the term treaty is more restrictive, and that's the part we have to be careful of. The U.S. government made their first official treaty with the Delaware Nation in 1778 and officially stopped treaty making with Native nations in 1868. The last tribe to make a treaty with the U.S. government was the Nez Perce. But they have, you know how we have Iktomi in our culture, we talk about the sneaky one. So the Iktomi move that the government did, their laws said that there were no more treaties. So they got real sneaky and they called it a new term whenever they needed more land from us. They call them agreements. So in our Ihanktuan, we have the 1892 agreement, and they thought, oh wait, we got to get more land from the Ihanktuan. So we'll call it an agreement. And so in a horrible treaty came about with our tribe. It's called the, let's see, you can find the 1858 treaty somewhere in there. The 1858 treaty was signed by my great-great-grandfather. When I became fluent with treaties, I felt so horrible. I thought, oh my God, 200 million acres were given away. All of eastern South Dakota was given away in the 1858 treaty. So I had to go down to Greenwood and talk to my grandpa at his grave, and I asked him, I said, why did you sign this treaty? Oh my gosh, this is horrible. And then it came to me, I was ranting and raving at his gravestone, and he has a really big gravestone. And then it came to me that how in the world did I know what conditions existed at that time? They were under martial law, they had a fort, women were being raped, just like the man camps, there was militarism, the kids were starving. In 1934, they told us that if we didn't take the Indian Reorganization Act, they stopped the annuities. They said, one of the agents said, you Yanktons better tighten your belts if you don't take the IRA. And bless our relatives, we never took the IRA. We are a non-IRA tribe, so we don't have a tribal council. We still have a functional, sometimes very dysfunctional general council, but we still have a traditional form of government. Major big stand in 1934. So we have we were able to stave that off. I know some of the tribes were not as fortunate. They end up having tribal councils and IRA governments, but you still have treaty councils and you have unceded territory and grassroots, so there's still a way to fight the battle. Okay, so we relinquished all lands except 400,000 acres. We literally gave away our whole homeland in this treaty. It's a horrible treaty. So, also the tribe relinquished to the United States the rights of the islands, and it goes on down the line. So what we've done, and that was this one here that was pushed out. So we went back down here and we've referred to what are called reserved rights in the treaty. Those reserved rights are the ones that are not spelled out specifically in the treaty. They still exist. So you have to study what reserved rights do you have in your treaty or in your homeland. And the other one is the unceded territory. The women literally have all of these rights because we've never signed any of them. This has no relevance to us. So we can exert this, and I'm trying to figure out, I've met with a bunch of women elders on how are we going to step forward on these unceded territories with the women standing there. That's something that still remains to be done, but we have to figure out a way to do that without getting too mixed up with this situation up here. So that one, let's go back to the 1851 treaty if you can find it somewhere in my stuff. The 1851 treaty, September 17th. What is it? Okay, 1851. The piece is supposed to be, and this is the one that we're using in the Keystone Pipeline. This is why we're making our stand. Peace is supposed to be observed between tribal nations who signed the treaty. And that was between other nations, of course. They weren't even thinking about the US government, but at the same time, they were part of that treaty. Now this one, roads, military, and other posts are agreed to be built on nations' lands. This one was tested by the Oglalas. When DM&E Railroad came in, they said, we don't want DM&E in the Black Hills. This one was to the detriment of the Oglalas because it says that we can use roads, military, and the Oglalas said it didn't mean railroads, but somehow, again, these courts are theirs. And they ruled that railroads could come into the Black Hills. So that one was a detriment to the Oglala case. The United States is to protect the Indians. Now this one we can combine with the 1868 treaty, which has the bad man clause. Some of you, how many of you have heard of the bad man clause? And that is essentially when bad men come into our land, we have to be protected from them like KXL. So we can use the 1868 treaty in combination with this one to protect against them. The Indian people are to be held accountable for any crime committed against U.S. citizens as they pass through Indian territory, and eventually, of course, the Major Crimes Act came about. And that was another sad story in their imagination, because in the Spotted Tail versus Crow Dog case, where Spotted Tail was killed by Crow Dog, the Native families actually were going to work it out. They were going to peacemake. But the government said, no, we have to take this to court. And they didn't listen to them. So the other thing you have to be careful of is we are never allowed to say no. The other legislation that is used against us, and you have to figure out this minefield on how you pick through it, the 1924 Indian Citizenship Act. They never even asked us if we wanted to be citizens. We were already citizens of our own. However, the only nation that actively fought the Citizenship Act, and I have so much, I put my hands up to them. Again, I wish we were all around in 1924, but people were starving. We were trying to survive, but the Iroquois nation said, no way, we are not going to become your citizens. And they made a stand. Consequently, they've issued their own passports. But that doesn't mean that we can't still do something. We have to figure out how we're going to do that. So we have to move on that one. So see, there's an exciting future ahead for the younger people that are coming up. These are the issues that you'll have to take on for the next 50, 100 years, is how do you make that stand? How do you assert it? Article 5, it just recognizes our boundaries. I think further down is a picture of the 1851 treaty territory. If you can find that map somewhere. Okay, there it is. That's the 1851 treaty territory. So that's the area, it's west of the Missouri River. So now, again, colonized behavior. So we have to convince our tribal chair people over here and to say, okay, Rosebud, Cheyenne River, Lower Brule, Oglala, they have titled land according to federal domestic law. But over here, we have 1851 treaty land. So we have every right to say, yeah, you're in my territory. So not having that behavior in place, we came into kind of a mini conflict with Rosebud. KXL is using Yankton against Rosebud by saying that Yankton did this survey for KXL. It was an awful survey. And I told the tribal government, I said, do not approve that survey. They're dangling 16,000 in front of you. Don't take it, don't take it. And I happened to be gone, and somehow they convinced to take that money. When the survey was done, it was really awful. So I went to the tribal government, I said, you have to dispute this, you have to throw it away. So they rejected it. But at the same time, it let us in as a consulting party. So now we stand on the 1851 treaty. We said, well, the reason why we're standing here is 1851. So Rosebud wanted to have our tribal government tell KXL that they were the primary consulting party because they have titled land. And so our people said there was a conflict there, and they said, no, we don't want to relinquish our stand and put you out front, we want to stand beside you. You know, what's wrong with standing beside each other? But it took about 2 or 3 months to work out this conflict, and I pray that it's been worked out. So we wrote a resolution saying that we support Rosebud, we stand by them with our 1851 treaty rights, and support the fact that they also have 1851 or 1868 treaty rights, but they also have titled land. They have a stronger stand actually than we do. But we don't want to get thrown out. This is the only thing that we're standing on is 1851 and the reserved rights. Does that make sense? So that's why you have to be fluent with these so we don't end up fighting each other. Because we could end up canceling each other out if we don't understand this. So this is what we'll be promoting in court. In that smaller area is the 1868 treaty, which is this area. This green area here, that's the 1868 treaty. And the 1868 treaty is really, really a cool treaty because it was found to be abrogated in federal domestic law. There was a guy named Salazar, and I can't remember the other attorneys, when Indian people, Native people started to come out of the starvation, the duress, they said, wait a minute, we never even signed that treaty. So they created the Indian Claims Commission, and they took their complaints to the Indian Claims Commission. But again, remember, there's people in there who have a different imagination of who we are as a people. Research for each one of you what the Indian Claims Commission said about your people. It's online. Better yet, go to Washington, research some of that. You know what I found out through Stephen Newcomb, the one that wrote this Pagans? He said that with the Yankton and the Western Shoshone, when our case went to the Indian Claims Commission, Congress said that you couldn't take any action until a report was done on the Yankton. You know what we found out? There was no report done. I got so excited when I found that out. And the Western Shoshone are standing on that. They're reclaiming some of their lands. So at Yankton, we've got this brilliant attorney, Thomasina Reelbird, was so excited. And so she's on this trying to figure out how do we use that. The fact that they never issued a report in the Indian Claims Commission because land settlements were based on the Indian Claims Commission reports. So find out what yours said to see the detriments and the pluses in there. So that's how you can use that. In the 1868 treaty, what happened is they signed because the gold rush was coming in. The chiefs said, you're coming into our sacred lands, we need to have this treaty. And so they signed the 1868 treaty, and it was a fairly good treaty, except for the railroads and the roads. So then the people with the imagination said, oh, we shouldn't have signed that. We gave them too much rights. So in their imagination again, they came up with the 1877 agreement, which took the Black Hills from the Great Sioux Nation. The 1877 Act, look that up. It essentially just took it back. It's like, whoops, I shouldn't have gave you that, I'm gonna take it back. That's literally what they did. So, the Oglalas filed on the 1877 Act and said it was obviously unconstitutional. Article 6 of the US Constitution says that our treaties are the supreme law of the land, and that was cited in that case. They actually won their case and said it was taken illegally. It's one of the rare treaties that has been proven to be abrogated, and a settlement was made. What was it, Kimberly? 17.5 million? Are you there? I think the original settlement to the Teton, the Great Sioux Nation, was 17.5 million. After that decision was made, of course, and you younger ones, you know this story, and this is a story you will have to continue in your coming generations. The Teton people said, no, we don't want that money. We want the Black Hills back. So it was that 1877 agreement that was proven to be wrong. And so now there was a group of people called the, I think it was the Different Horse family out of Fort Peck. These lawyers, they get, they see some of this and they understand Indian law, the imaginative law, and they kind of rub their hands together and they say, we're going to find us some clients. They found some clients in Fort Peck, and they convinced this family that they had a right to file for that Black Hills money, that they were being denied a tribal right, a nation right. And so they took it to court, and everybody was afraid because, again, we risk things when we go into these courts, but luckily they ruled against them and they said they could not represent a nation decision. That was close. That was just recently, maybe within the last, 3 years? So now that money is safe now, they can't. But for your future generation, if you don't know this, a lot of the old treaty folks are passing on. So the younger ones have to step up and say, we are not going to take that money. We are going to try to figure out how we get the Black Hills back. So that's what the 1868 treaty, and of course, obviously, it's in the Keystone Battle again, but we have to be very careful of not getting it into court. We can talk about it, we can assert our sovereignty. The reserved rights have never been tested, some of them, like water rights, the Winter's Doctrine, which says that we're senior users. Remember I talked about the Yankton case, the hog farm? In the hog farm case, we learned so much that we should have done. Really painful case. What happened was, like I said, that Head Start mother, she lost the case for us essentially because they represented her as the nation and they threw it out. But on the other hand, there were some of us that said, we have certain reserved rights, like the water rights, the Winter's Doctrine, which is a case in Montana, that said Native people are senior users of the water and we have to be first. So we asserted in the hog farm situation, it took us 3 years, 5 of us filed, Thomasina represented us, and you know what, if we had not filed, this is really scary. It went before a hearing, kind of like the PUC committee, and it went to peer. But even though they let the hog farm go on, in that case, they said that a senior user of the water had stepped forward, the Yankton Sioux Tribe, and that right was preserved, but it wouldn't be debated in court. Just think if we hadn't done that. The hog farm would have had a senior right to the water. See how scary that is if you're not educated? If we had not appeared in that case, whatever that hog farm company's name was, they would have gotten the senior right to that water. So even though we lost that, we still have asserted, and what the attorneys did to get out of it, they said, in the state of South Dakota, the Winter's Doctrine reserved water rights have not been tested because this tribe does not have quantification. We have not tallied up how much water we own. That's the other battle that's going on with reserved water rights. So there's many fronts where it's like a minefield. You have to understand all of this to get through it. Now, back to Tex Hall. I see. Tex Hall was on a drive to get everybody to quantify their water rights on the Missouri River. Guess what? He wants to sell the water. So ITARC was created, Intertribals, I can't remember what it stands for. But he got a number of tribes, including Yankton, and we got on because we wanted to keep an eye on him. And we can step off if it goes in a different direction, but we want to be in there to see what they're doing. But he was pushing really hard to get these tribes to quantify their water because he wants to do that for Fort Berthold. You just hurry up and do it. And a lot of them don't understand all of this stuff that we just talked about. So now he's not, I think he might still be on ITARC, but we still have to keep an eye on that because he has these connections in Congress. He was really pushing it. The rest of the story with water rights, the government's tactic in the state of Montana, they forced the tribes to quantify their water rights. They said, if you don't do this, if you don't quantify your water rights with the state, we're gonna drag you into court. So the tribes in Montana came to the table and they've started quantifying their water rights. In the Oceti-Sakowin, a lot of the older people will say, I will never quantify the water because all of it is ours. So there's a pro and a con, because if all of it is ours, we should be keeping an eye on every single permit that is issued out of DNR. We're not doing that. You know, CAFLs get permits every day. So we don't have the inner capability to keep an eye on our water. So that's the downside of it. We're not keeping track. The Corps of Engineers is saying now that they're going to charge for the water. So all the tribes rallied and they attacked the Corps of Engineers and they backed off a little bit. But that's where they're moving, is they're going to try to sell our water. So that water rights, oh my gosh, that's a big one. It's just trying to figure out. On one hand, we should quantify it so we can own it. If it was quantified, we have a stronger stand with KXL. But if we don't quantify it, we have more water rights. It's just a tough one. I don't even know. I can see both sides, but it has to do with the treaties. The water rights are based on the treaties. Okay? So that's how 1851 and 1868 treaties tie into this. And I think, again, many of the treaty people that sit over here, they're Lakota, Dakota speakers. There's kind of a chasm between them and the elected leadership. And in response, the elected leadership will starve them. They won't let them know what's going on. It creates anger on their side. And they say, I'm going to stand by the treaty, and it's hard to come together. So when I saw that happening, when I came into the Treaty Council, and on our Treaty Council, I don't have to worry about not getting reelected because I'm a lifetime member unless I go steal a car or do something, then I'm on there for the lifetime. So I've got a little bit of time here. I got a lot of time where I figure out I'm going to work with these guys over here. I'm going to stalk them. I'm going to figure out what they're doing, make sure that they get us to the Great Plains Tribal Chairman's meeting where a lot of decisions are made that are treaty decisions that we're not aware of. So rather than saying, oh, our Treaty Council fight all the time, go in there and learn, encourage them, because they come from a generation where they were really oppressed, and that's what we were colonized to do to them. So a lot of the old treaty folks are really angry. Well, once I figured that out, I thought, you know, I'm going to work with all of them. We're going to work with all of them, and we're going to try to figure out, even if two of them are fighting each other, we're still going to figure out this is about the land, water, and the grandchildren. So it takes a lot of decolonizing to do that. And sometimes you don't even know you're colonizing when it's happening, unless somebody tells you. Because it's so invisible and it's so insidious. And it goes to the point of saying, well, I don't like to talk to that one. Right away, you've created an invisible line. Okay? Okay, questions, comments? Is this a little bit helpful? Seeing how you view the treaty? The most important thing is the education and the awareness that you have to be really careful about risking your treaty, but it's how you behave and how you act as a sovereign. Yeah.
I should know this answer, but I'm going to ask anyway, because, so, you know, 1887 they took the Black Hills, and when did they create the reservations now that exist in South Dakota? So is that
yes.
That
yeah.
movement? Yeah,
the Great Sioux Nation on the west side of the river was created. So our part on the eastern side of the river was by individual treaty, like ours was created by the 1858 treaty, but that also created the Great Sioux Nation on the west side of the river. So that was a really destructive act. And of course they weren't happy, so they came up with the Dawes Act. and went after more. Yeah, somebody else had a question. Did you?
Yeah, I don't know, I was just gonna say that we have an IRA government from our 1934 Constitution, but that's one of the things that we can use for us, because our tribal government tried to use it against us back in 1997. Tex and all those guys changed some things in our Constitution without going to the people.
Okay.
And one of the ways that we're able to stop some of these new things from happening within the oil boom is by using that Constitution.
Yes.
So you can change.
You can use it because each one of the IRAs that came in, they created a constitution. So that constitution governs how you behave as a people.
Right.
Now, with the non-IRAs like us, we have a constitution that tells those elected leaders how to behave. So it's a little bit different for ours, but at the same time, it's similar. So you can hold it accountable.
We had to put an ethics committee within
Yes.
our constitution because there was no separation of powers, no ethics
Yes.
going on there. So that's one thing we did, but a lot of people don't even know that they're still operating underneath like the 1934 Constitution. And
There's
that they
confusion
can
about which
change.
constitution.
Exactly.
Every tribe does
And
that.
if you go online, you can see all of the constitutions, but they don't update them. They're all from 1930s.
The original.
So you have to be careful because that might not be the tribe's original
Yeah.
anymore. They might have changed it. So I just wanted to mention that.
Yeah, and the other thing to do, and I'm glad you brought that up, is that some constitutions retain judicial power. So even if you have a CFR court by the Code of Federal Regulations, or if you have a 638 court, if you've retained judicial power, you could actually change some of the tribal court decisions if they're contradictory or they're not helpful to your nation. Because in our tribe, our general council retained judicial power just like it did in the old days. So examine in your constitution whether or not where that judicial power went. Okay? Any other comments, thoughts?
I really do appreciate that, Tony, for giving us the insight about the foundation of our treaty rights. There's a number of phrases I've heard out there. You can take them as you wish, but the idea that we are all treaty people, that in this fight and in supporting our rights and acknowledging our rights as Lakota or Dakota Oyate and our recognition of treaty rights, that non-Native people in this fight to protect Mother Earth are also beneficiaries of that. You know, the protect Mother Earth and the struggle to protect the water. And I think you did a really good job of presenting that this discussion of treaty recognition and our recognition of our sovereignty and our treaty rights is not necessarily a fight that we want to do within the court system of the United States, but something that's on an international level. So a lot of people, you'll see a lot of our Indigenous people that work in the United Nations or on an international level to elevate the treaty rights, because you can't really seek for justice within a system that its whole purpose is unjust and is to extinguish that treaty right. But it is something that we can use in this fight to increase just the acknowledgement of our status as political entities, as nations. A lot of tribes in this fight have asked for proper consultation and consent, and that has not been given. And TransCanada has not. TransCanada and also the State Department have not done due diligence in obtaining free, prior, and informed consent from the tribes here in South Dakota, Minnesota, or Montana, which is an often thing that happens a lot. And so the argument that the tribes are putting forward in the PUC, as well as on a national level with Obama and the State Department, is we were not properly consulted. And that's been established in international law. So our non-Native relatives understand that. So when you are asking for us to, when we ask you to stand up and support, that's one of the main arguments is proper consultation with the tribes. As she expressed, that there was a consultation that said, oh yeah, we talked to Yankton, but it was flawed and it was left out and it was inadequate. And even the tribe itself says, that wasn't proper consultation. And all the other tribes said, well, you consulted with this one tribe. There's the rest of us, and you haven't talked with us. And the Oceti-Sakowin as an entity, as a nation overall, there hasn't been proper consultation. So those are just things to remember going ahead. And I really like something that what you said about being careful. We as Native people, as Lakota, as Dakota, being careful when we say recognize the treaties, acknowledge the treaties, is that you have to understand what's in those treaties. You know, that it is in the 1858 treaty, is it 58? Where it says they have the right to put infrastructure and roads through with due compensation. So that could be used against us. They said, well, we can compensate you, we meet the terms of that treaty. So we have to educate ourselves on that as well. But there is like the bad man clause, is a clause that people want to see if we can elevate that as a strategy that the United States has to basically, when we identify someone as being a bad man that will hurt our nation, that we have the right to kick them off the res, which has been used in the past. Yes.
I just wanted to ask you too, how does everybody around here feel about the dam? Are most people, you guys like having the water here? Like, because at Fort Berthold, one of the things that's emerging is to push for the decommissioning of that, because the reason the Army Corps of Engineers has all that power is because they built the thing, and so they own all of the shorelines, and they say the surface waters too. I don't know how they own the surface, like they go down and scoop them up and then it's yours or what, but I think if the dams, if the dams were just decommissioned and the rivers were allowed to flow again, would that be our water then again? You know, how would that work? And what do you guys think?
So let me come back to that question and remind me, because senior moments pop in. But one that I want to say up here where we need some decolonized behavior from the rest of the bands to help us, and we're decolonizing too. If you look at this clause, it says in 1858, and this was a powerful one in the 1858 treaty. This is the saving grace. It says, Yanktons are granted free and unrestricted access to the Pipestone Quarry. So struck by we refused to sign this treaty unless we retained our rights in the Pipestone Quarry. But the predators, being that they concocted some bribes, and they got a crazy vote from the Yanktons to pay per cap for the Pipestone Quarry. But it was an illegal vote, and so what we do is we act in this chair over here of saying that was illegal, we still have this right, I'm here, you recognize me, and I want co-management of that quarry. So what they tell us in their colonized behavior, they say, well, there's 26 tribes that say that they own that quarry, and you're gonna have to get those 26 tribes to agree with you. And when they get on the phone with those 26 tribes, they'll say, well, Yankton's trying to assert, you know, the colonizing. The way they talk to them, they set us against each other. So we are in the treaty seen as the overseers of the Pipestone Quarry, according to their ugly definition of it. So what we ask is that the other tribes support us and help us and stand beside us. Just because we happen to be in the treaty doesn't mean the Pipestone Quarry doesn't belong to you too. But somehow we have to decolonize and figure out that's a battle for the next century. And hopefully it'll be maybe in 10 years. For your generations, I ask you to fight for the Pipestone Quarry to come back to the Ocheti Shakome, because it's all of ours, but it is in this treaty. So that's one strength that we have. The other thing I wanted to say, and I think Kimberly's off the folder, but on this one, there's something positive that came out of a court case, and I'm going to ask Tonshka to fast read these 4 items. You can tell where I was reading this. Those 4. Read that paragraph and that one.
These sentences?
Yeah.
I can read. The courts recognize that the past exploitation of the Indians could not be sanctioned by the force of law, and hence developed a set of judicial rules by which to deal with these problems. Among the more important rules of construction are ambiguities in treaties are to be constructed in favor of the Indian claimants. Indian treaties are to be interpreted as the Indians would have understood them. Indian treaties are to be liberally construed in favor of the Indians. Treaties reserve to Indians all rights that have not been granted away, reserved rights doctrine.
So that's on page what?
48.
48. Learn that one, because that gives us power that is as we understood it, because the majority of those treaties were conducted in English, and our forefathers didn't even understand some of it. So we can add that other layer in that is established by court, and it's explained on this page 48, that it's as we understood it. And that's what we understand, and that's why we're fighting KXL. Very, very important. Now, the other thing in regard to your question about the water, every time something comes before your people, part of your decolonizing is you really have to understand it when it involves money, because money is capitalism. Okay, so how many of you in here received Salazar money for your tribe? Raise your hand. Okay. All right. So, let me tell you about Salazar. The Yanktons were the first ones to file for Salazar in about 1992. And our main motivation for doing that was because of the dam. We felt like we were robbed of that hydroelectric power. They were gaining millions, billions of dollars, and that was our main motivation, was the water. So we filed for what, kind of like the Cobell case, not with leased land, but over here with resources that were mismanaged. So Salazar says that all of those areas that trust responsibility through the Bureau that was supposed to be taken care of, for example, what happened with Big Ben, your rights were violated. So the lawyers calculated how much you would get in Salazar. It calculated many other things. And so when it came before Yankton, I didn't feel right about it. I thought, this is another buyout. Anytime Coyote offers you something to eat, that's dangerous. Especially if you're really, really hungry. So I looked at it, and I was agonizing. It came before our people, and they offered us $6 million. And right away the people were saying, oh, just think. And one of the leaders was in the back of the room, and he was saying, you know, if you vote for it, you get $300 a piece. I about hit the ceiling when somebody came and told me that he was saying that back there. I ran back there, and of course he ran out of the room. But I said, you cannot take this. We don't even know what this $6 million is for. And so we had 4 votes at Yankton. The third vote, I thought the next time around they're going to win. The treaty committee, you got to get people there, you got to get your families there to vote this down. So I was so just agonizing, and so I prayed about it, and I had this dream. In this dream, my grandmother's name is Lillian Marie. She's the great-granddaughter of Struck by the Ray. In the dream, I was walking up her old house, which is no longer standing there, and there was a window here, and I saw her laying on a table, and she was wrapped with Indian blankets, and she had her long white braids, and I thought, oh, Grandma already died. What is this? And I knew I shouldn't go over there, but I saw her laying there. And then I went up the stairs. My Chuez and my family and other people were running around cooking. I could smell coffee. And I said, what's going on? And my older Chuez said, I think we're going to find out. She said, we're just taking care of things. And she said, I don't know yet. And she's kind of the boss in our family, so I was thinking, what's going on? And then my kids came up and they said, Ina, what's going on? And I said, I don't know. And then I looked up, and this big old room opened up. There was a big, long table, like a negotiating table, and there was a whole bunch of older people from a long time ago sitting around that table. Some of those had those tight government suits on, some had feathers on, and they were all looking at me, and nobody smiled. They just kept looking at me, and I got scared. And I thought, well, this is disrespectful for me to be staring at them, so I put my head down, and I looked up, and another room opened up. Same thing, different people, same scenario. So I put my head down, and another room opened up. And I knew that if I kept doing that, they would keep appearing. So I just kept my head down, and I can't tell if I actually heard the words or I felt it in my spirit, but I heard my grandma's voice, and she said, there's something in the treaty. You need to look in the treaty. And the phone rang, and I woke up. And I thought, I knew it was a spiritual dream. It was very clear. So I took coffee to her down at where her old house used to be. And about 10:30 that morning, I checked my email, and I got an email from Thomasina. And she said, Faith, I found the railroad treaty. And she said, it says in there, it was supposed to be land returned, and if not, that we can get compensation. Immediately, I looked at that and I thought, oh my gosh, that wasn't even on Salazar. So they've calculated the mismanagement on that, and it's up to 31 million on the railroad. It's right, as of last week, it's up to 41 million, and she's still investigating. So if you took Salazar, you negated some of your rights. So you have to examine what you negated during that period of time. So each tribe, and see, it's not your fault, because this chair over here didn't understand. But I understood. I knew that every time you sign something, you're going to be giving something up. And so to this date, we have not taken the Salazar. And right now it's up to 41 million, but we have to calculate when it comes to that floor, you're dealing with poverty, you're dealing with families, so we have to educate those families. And so in regard to your answer about the water, you have to look at what Salazar did, what rights that you may have relinquished, but you have reserved rights, and you have winner's doctrine. So we have to come together, and that's a unification, is talk to each other and say, how are we going to do this together? Because we can't offset each other. And it might be international law. Those are the things, you know, my dream is that we could have a treaty meeting where we would come together and bring the best international lawyers, meet for 7 days and figure out where we're going to go for the next 50 years on treaty rights. What do we need to protect? Because we don't talk to each other, we're in isolation. That's a colonized behavior.
We fought against it back then, but nobody's doing anything now.
There's no strategy.
Neither one hydroelectric power either.
Yeah. So there's real no strategy going on. The last thing that I want to say, and I know Dallas is telling me, stop, I can hear it, is if you could find on the internet for me, the International Treaty to Protect the Secret, you could go online on that one. So one of the strategies, remember when Dallas talked this morning and last night, he said each one of us is going to search for ways that we can do this fight. However creative, spiritual, prayers are the strongest, that we can fight this battle from native and non-native in alliances, because when we had that White House meeting this summer, when the Reject and Protect, the one thing that we got out of that waste of time meeting at the White House was they said that the president is noticing the unlikely alliances that are coming about. So the power of the alliances that are coming together are major. So when we looked at that, and after that dream came, I think it's a sub one on there. It's on that site, but it's somewhere in there.
You want the actual treaty?
Yeah, or the video. There's a video on there, you might have to go further. So what we did after that dream came, the treaty committee got together and the spirit started to move. I thought, you know what? We need to call other nations. Why don't we, just because they said that we couldn't have treaties, why don't we do our own treaty? So I looked at our treaties. In 1863, on January 25th, we signed a peace treaty with the Pawnee, who were our hated enemies. So I called up the Pawnee, and the person who answered the phone was Gordon Adams. He was the TIPO. And I told him, I said, we're thinking about trying to revisit this treaty. And we signed a peace with you all, and we'd like to revisit that and create a new treaty to stand against KXL, who are the bad people coming into our territory, and I know they're in your territory. And he thought about it for a while, and he said he's got the southern accent. And he said, you know, that's really curious that you asked, because he said, my great-great-grandfather was a signer on that treaty. So I don't think that was an accident. And so he got the ball moving. The Pawnee came up on the anniversary, and I'm going to show you the signing here, and that'll be the last thing that I'll do on the treaty. Is it coming up?
Well, we could probably eat, and then I can play.
And then you can play that afterwards. So we, in January of 2013, we convened this huge meeting against the KXL pipeline, and we asked treaty councils to come, we asked IRA officials, and we asked a number of the tribes to come, and after lunch, you'll be able to see the signing of this international treaty. We went up, and that's where I met Heather, in Ottawa. We took the treaty up to Ottawa, and we had 6 First Nations sign it. We need to have a huger, big treaty signing of our international treaty, but because of unawareness and maybe colonized behavior, only one other Lakota tribe in the Oceti-Sakowin has signed our treaty, and that's the Oglalas. And I really thank the Oglalas for signing. So the signatories in the Oceti Shakoi are the Woglawas and the Yankton on this international treaty. The Tsleil-Waututh in Washington, where Enbridge, you've heard about them protecting the western part where Enbridge is coming through. They saw this treaty and they adopted the 7 same principles, and they've created the international treaty to protect the sacred in the Salish Sea. So they've done a like treaty and they've signed it, and so we're going to bring them out here hopefully, and we're going to invite other nations to come in because we really have to relearn how we use these treaties in international law. And I understand in Canada they have a Buffalo Treaty now. Some of the nations started a Buffalo Treaty, so we need to get together and figure out how are we going to use these treaties. We were contacted by the UN, and they wanted us to present this treaty, but we're not quite ready to throw it out there to figure out how people are going to pick it apart, and we have to be careful. So after lunch, we'll play that one, and then you can have questions about it. But thank you. Lunch is here.